Right, I'm going to begin this webinar um, and say thank you for all those that are in attendance this afternoon. We are producing this webinar to cover the Renters' Rights Bill as it stands at the moment and do some promotion of the Cornwall Responsible Landlord Scheme and give a little insight to why the scheme was developed and how we hope to help landlords and letting agents in Cornwall. Okay, so I'd like to welcome everybody. We have presenting today, we have Luke Best and Laura McLaren, who are helping to facilitate the webinar. And we have Keith Anstis and myself, Martin Diamond from Private Sector Housing, who deal with housing conditions in the private rented sector. Okay, just some house rules. This is that you need to be aware of. This is a public meeting. Your name may be visible to other attendees. The session will be recorded and we will be publishing it, so it will be available if you want to revisit it or for those that haven't been able to make it today. The microphones are muted and cameras are off. You can ask questions by typing it into the chat box, and we will endeavour to answer as many questions as we can at the end of the presentation. Okay, so what we will cover today is the Renters' Rights Bill, the main provisions and its progress, where it is today. We will be looking at the Cornwall Responsible Landlord Scheme and how that aims to support landlords and agents as the legislation arrives. And we will look a little bit at CRLS development and progress of the scheme. I would say, really, with regards to the Renters' Rights Bill, it's still on its passage through Parliament, and there still are amendments being made, so there still could be some changes that are unknown at this point. I'd also like to say within that I'm going to talk a bit about the Decent Home Standard. The Decent Home Standard has been around for many years, and again, it's been out to consultation before its implementation into the private rented sector, and the outcome of that consultation isn't known as yet, but I can share some of the thoughts around how it may be amended or changed. Okay, so the Renters' Rights Bill, introduced by the previous government and now being delivered by the Labour government. These are words from Matthew Pennycook. I won't read them all out to you, but I think there's some quite powerful and strong words in there where he's talking about an insecure and unjust private rented sector, levelling the playing field between landlords and tenants, giving tenants greater security, rights and protections. The bill aims to drive up the quality of private rented housing, and it will enable new powers and provisions for local authorities to crack down on unscrupulous landlords who reflect poorly on the profession as a whole. That's landlords and letting agents. Okay, so the bill is broadly broken into 4 parts. The first part of the bill will cover tenancy reform with the abolition of assured short-hold tenancies, abolishing Section 21 no-fault evictions, some new controls around rent increases and other rent issues, and not to discriminate against people who have pets. Still under Part 1 tenancy reform, we've got new duties on landlords around giving information to tenants. We've got changes to tenancy deposit requirements, ban on discrimination to children, people in receipt of benefits, and a ban on rental bidding, which is where it's reported agents or landlords have been advertising properties with encouraging people to bid how much they're willing to pay, and that is seen as discriminatory, and some limitations on the amount of annual rent increases. As part of Part 1, there are some amendments to other pieces of legislation. There's financial penalties as an alternative to prosecution, and the application of AWAB's law to the private rented sector, which is around dealing with dampness and mould growth within accommodation that is being let. On that latter point, The understanding at the moment is it's not an offence to meet AWAB's law as not meet AWAB's law as such, but it will be a matter which the Housing Ombudsman would investigate and on behalf of tenants ultimately for lack of or no responses by their landlords when they report such issues. Part 2 will introduce provisions around the landlord database, often has been referred to as the landlord's portal. So tenants can find out information and make better choices when entering into tenancies. And landlords to understand their legal obligations and demonstrate compliance. Through the portal, we understand that will assist local authorities to identify properties who are that are not compliant with the new requirements, actions or activities by the landlord. Okay, part 3 introduces decent homes to the private rented sector, and if a property fails to meet the decent home standard, the local authority will have a range of options on intervention, with the aim of trying to improve the quality of that accommodation up to what's considered to be a standard decent for modern society. Part 4 introduces a raft of enforcement responsibilities and duties to the local authority. So it will be our responsibility to make sure the new legislation is being adopted and complied with by landlords and letting agents across the county. Some new powers around entry into premises without the need for warrants, offences for obstruction should someone prevent us investigating a potential breach, and requiring information and such like. So the decent home standard, I wanted to look at this in a bit more detail. It forms a major part of the Renters' Rights Bill and will have direct impact on many landlords, particularly in Cornwall, I would say. Can we have a look at the... Okay, so what is a decent home? This has been discussed for well over a decade by government and ministers who've made various announcements on what it should be. So it was initially introduced as a standard applicable to social housing, council housing, looking at regeneration and renewal up to a modern standard of decent homes for people. So it was introduced for social housing, and later it was extended to private housing occupied by vulnerable groups who were considered at the time to be living in the poorest conditions, the private rented sector. Government went on to say, as I say, this is slightly historic, decent homes for all. So it was transforming social housing, including vulnerable households in the private rented sector. And it was the first time used as a benchmark for private rented sector for reporting by local authorities, where we had to deliver reports to government on how many vulnerable households were living in non-decent accommodation in the county. And the underlying figures which underpinned decency levels were arrived out of the English House Condition Survey, which are carried out approximately every 10 years. Okay, so again, government policy, they had a lot to say about decent homes. Government progressed the decent home standard to deliver investment in social housing, and part of the decent home standard, which we will look at in detail in a moment, and a major part at this time and potentially now for many private landlords, is it enabled costing to enable renewal or replacement decisions. I think in the context of private sector landlords, it's more about being mindful of the need to invest in your in accommodation you let, and to help influence those decisions about making smaller repairs or actually making an investment decision on replacement. So there were 4 factors to what constituted a decent home. We've got the minimum standard for housing, it had to meet that. It had to have reasonably modern amenities and services. reasonable state of repair, and a reasonable degree of thermal comfort. The minimum standard for housing, the first criteria, it was previously defined as fit for human habitation in the 1985 Act, and this was then replaced by the Housing, Health and Safety Rating System introduced by the Housing Act 2004. That was seen as a more modern system, a more robust system for looking at hazards in dwellings. When inspecting officers look at properties, they identify defects and deficiencies, and these are scored, and we end up with a category 1 or category 2 hazards. So high scoring hazards are category 1, lower scoring hazards are category 2. And this presented the duty for local authorities as to whether they had to take intervention action to resolve the hazards, or they had discretion whether they had to take that action or not. So that considered the minimum standard for housing within the Decent Homes framework. So state of repair. So one or more key components are old and because of their condition need replacing or major repair, or two or more other building components are old and because of their condition need replacing or major repair. So here we have a chart which was given to set out the expected lifetime of building elements, really to inform people about how they can expect those elements to perform. So these are in years, wall structure, 80-year lifespan. At the end of that, if it's in disrepair, you really need to be looking at the extent of disrepair and whether it should be repaired or replaced. So this was really around funding and having insight into the investment that was needed into the property that was being let. Poor condition. So we have a percentages, or certainly higher percentages you would lean towards it is in poor condition and is in need of replacement. And it had third criteria, reasonably modern amenities. A dwelling is not considered to meet this criteria if it lacks 3 or more of the following facilities. Okay, so we can see really they're giving 20, 30-year lifespans for kitchens and bathrooms as an indication of when they should be considered to be replaced. And a reasonable degree of thermal comfort. Now, I would say this is from the original Decent Home Standard. There have been some tweaks around this along the way, but really it's about having adequate heating for the property, which are efficient, and that's not only in terms of energy but also in cost. So there were some tweaks certainly within the housing health and safety rating system that would capture those efficiency and potential savings. So government, again, the statements around this was that they wanted a high quality private rented sector, they wanted more choice, they wanted options for people, rights for tenants, and to ensure that responsibilities in regard to accommodation which being let are being met. They wanted to increase professionalism in the sector, and again, different wording, but the same meaning really is drive out work practices that damage its reputation. They want the previous government, the Conservative government, wanted to create a bigger and better private rented sector. And again, it's a similar statement, different wordings, but really they want to investment in the private rented sector, increasing the amount of accommodation available, and preventing rogue landlords exploiting the market. And by doing this, by introducing certainly these bills provisions, they felt that this would lead to a bigger and better sector. And I will just touch on the Renters' Rights Bill, its current position. The bill has progressed through the House of Commons. It now sits with the House of Lords. It's had 2 readings in the House of Lords, and it's actually at the committee stage. And the indication at this time to the local authority is that parts 1 and 4 will commence in the spring, and we will have duties from the summer onwards, and really the enforcement tools from early 2026. So that's where the bill is at the moment. It's still got another stage after it's been through the committee stage before there are still many amendments being tabled and debates to be had. So I think there's quite a lot of fear in the press and the media around what this means for landlords when we don't really know the true detail at this point. Certainly, this government and previous governments' aim was that this bill should reach a balance between what's good for tenants and what's good for landlords. But certainly, some of the terminology you hear is quite concerning for many landlords. But I think once more detail becomes apparent, we will be able to give some assurance that the majority of landlords not to need to have too many concerns around this requirement. The other thing I wanted to mention was around decent homes. We looked at that just now. There was a consultation for introducing the decent homes into the private rented sector. That ended a couple of years ago now, and we still don't know the outcome of that consultation. Certainly some of the aspects I've seen is where they were considering where under the decent home standard you consider reasonably modern amenities, it was to drop the element relating to age. So certainly the local government association argued that its condition is far more important than age. Something that's quite old could still function effectively and be fine to use, and therefore it shouldn't be discounted at that point. So I was just going to end really with this around the Cornwall Responsible Landlord Scheme, and I'm now going to talk about the scheme and why it was developed and how hopefully it can help landlords and agents across the county. Okay, so the Housing Act 2004, it imposed duties on the local authority. One of the Part 1 functions is to review housing conditions. So the local authority has to consider the overall condition of the housing stock and where it should prioritise intervention or assistance. It was difficult to review the housing conditions without a stock condition survey, and the Part 1 also introduces the housing health and safety rating system and duty to take action for serious hazards that are identified by the local authority. From a local government perspective, it's a high priority issue locally and nationally. It's a rapidly expanding market. At the time we were considering introducing the scheme, there were new landlords, emerging landlords and agents, some of which were internet-based only, and it was proving very difficult to have any regulation of those landlords or agents in a virtual world, basically. Local government was being encouraged to promote better businesses and offer support to businesses, supported compliance. You know, we can certainly help those businesses, landlords who want to be helped easier and less resource intensive than intervention or enforcement action. At the time, there was a reduction in local government resources, and there was some provision of tools to try and help us assist in improving the private rented sector at that time. So we looked at the housing stock in Cornwall, and it was almost half the private rented sector at that time was identified as being non-decent. The local authority was mindful there was about £100 million in housing benefit expenditure in the county, and whilst the majority of that was going to satisfactory, good quality accommodation, there were some elements of housing benefit that were actually funding for substandard accommodation by people who couldn't manage their properties in an acceptable manner. So what I'm trying to say is really there is taxpayers' money going into the private rented sector, and we wanted some assurance that that wasn't going astray and being used by unscrupulous landlords. We had high-risk houses in multiple occupation, so those with the greatest stories at that time and large occupancy levels not being managed appropriately or unsafely in some instances. We had the presence of vulnerable groups in the private rented sector, and we had also some exploitation occurring across the county at that time. So the Cornwall Responsible Landlord Scheme. Okay, so we conducted a stock condition survey to identify that a large portion of the stock here didn't meet the decent home standard. That was really mainly around energy efficiency, poor thermal comfort, but also hazards such as falls on stairs, very common in our certainly our older housing stock. Staircases, very steep rakes, no handrails, inadequate lighting, and uneven treads and rises, and they all presented serious hazards, and that was of course of a concern. And how are we going to address that? We did a skill survey really across landlords and agents in the county to try and see how well the legislation and requirements were understood by those working in the sector. And then we hosted a landlords forum debate around licensing all accommodation across the county to try and drive up standards of management practice, or accreditation as a means of really helping those people that wanted to be helped and were able, therefore, through accreditation, to isolate themselves from those who were unscrupulous in the sector. And then in 2014, we started to look at the evidence, the views we collated, and what options we had. So our approach at Cornwall Council in private sector housing was to try and gain a better understanding of the market. We did the survey to identify skills gaps. We considered licensing, accreditation. We did consultation, and then the decision around whether extending licensing beyond the mandatory regime or accreditation was the way forward. So landlords and agents, what do they tell us? They told us they didn't want licensing. Two main reasons for that. There was costs associated with any licensing, and also the administrative burden. And that was seen by the landlords who were consulted on this as really penalising those landlords that were already compliant and doing the right thing. Like accreditation. Accreditation, again, that had a cost element to it. As a local authority, we couldn't fund accreditation through council tax. It wouldn't be appropriate. We had a debate around the benefits of licensing, and we had input from Newham, who had introduced borough-wide licensing, and they saw that as the way forward, certainly in that urban area. And there was arguments for the benefits of accreditation, really. And what we arrived at really was that the way forward for us would be to deliver a voluntary registration scheme. So in developing the scheme, we thought it was much better to have a partnership approach. So we engaged with ALA, the National Landlords Association, the South West Landlords Association, and the Cornwall Residential Landlords Association to act as partners on this scheme, really to show we were working with bodies that represented landlords and letting agents in the sector, and we were working together to try and improve standards and quality of management in the private rented sector. Apologies, I will just say I've noticed that the some of the three of the logos at the bottom there have not been updated, so apologies to those organisations. I will make sure that that is put right. Okay, so the partnership approach, it had to be free, so there would be no cost. There would be a very simple membership process. We ask for a name, email address, and number of properties. We don't ask for addresses if you want to be a member of the scheme. We're trying to gauge not only how many landlords that we're in touch with, but also how many properties potentially could be covered by the information that we provide through the scheme. And those that were willing to engage through the scheme and trying to do the right thing to try and assist them to improve the standard of their accommodation. It also introduced a code of conduct, how we expected landlords in the county to behave. That was broadly taken from the Royal Chartered Institute of Surveyors Code of Conduct when letting accommodation. Some of the main points of that which we felt were essential when you were managing accommodation. And it also, the scheme enabled the introduction of the Cornwall rental standard, and there never had been a standard for Cornwall prior to the introduction of this scheme. So that's really just a screenshot of the branding that the partners and ourselves agreed, and that's really should form the basis of any materials you see that relate to CRLS. So just a little bit on the Cornwall Rental standard. First time that landlords can see what a let property should look like. We were able to focus the standard on the most common hazards we found in our housing stock through our inspection processes. So and then we were able to provide guidance to CRLS members on ways of addressing those hazards. If they felt those hazards existed in the accommodation that they let, we would actually guide them on the appropriate best ways of addressing those hazards. Currently, membership of the scheme comprises mainly landlords and letting agents, some who have an interest in the sector in the county. There's currently over 1,100 members, and in total that captures about 14,000 properties. Okay, so here we have again the branding, just an image of the branding with the correct logos for our scheme partners. I see, thank you. And there's information there about how you can join up. You can join up on the Cornwall Council website, or you can email the scheme and get more information. Talk to one of the officers delivering the scheme to find out really if it's right for you. If you had a particular query, then we can help. We like to try and assist more for scheme members. We really want these landlords to be well informed, and would perhaps give a slightly more information support, certainly, for those that come forward through the scheme. Thank you. We can consider any questions that we've had about this presentation.
Yeah, so I'll read those out, Martin.
Okay, thank you.
Yeah. So my daughter is a student and has in the past come across being gazumped by someone saying they will give 6 months upfront rent. Are there any changes around this?
Yes, there are proposed changes. They're not finalised, so it may change, but there are provisions aimed at stopping such practice, and limit the amount of certainly rent in advance deposits that can be asked for at the start of a tenancy. And there's also elements of rental bidding, which is around similar to gazumping, really, to stop that happening.
Okay, thank you. Question from Jan: does this apply to supported housing? We use license agreements as opposed to a short hold tenancies.
My understanding is it would, unless there's an exemption that applies, and I haven't got all the details of any exemptions at the moment. So that is another question which will come out in fine detail.
Okay, another question. So from Mark: define modern. Would a fit and functioning kitchen from 1990 be okay?
It would, as long as its condition is sound, as long as everything works as it should, functions correctly. Yes.
Okay, another question. So from Mark: rights of entry without a warrant. What checks and balances will occur to stop this being misused?
Okay. I think really we would be very careful and wary of stepping outside of any legal framework that's put to us for use of powers of entry. Usually the reasons are for collecting evidence, and the purpose of not giving notice is to secure that evidence before it can be removed from a premises. So there will be checks and balances to make sure the local authority hasn't overstepped its remit, and if any subsequent action is taken, there will be grounds for appeal should there be a scope for inappropriate misuse of powers by the local authority.
Okay. One from Daniel. Are there any updates on the renters' rights within this bill to end tenancies early?
My understanding is not for the landlord's part, but for the tenant's part, I think there's a shorter time frame certainly being debated. Is whether tenants are could give less notice in certain circumstances. Again, the whole tenancy reform has a lot of amendments, I feel, to be made at the moment. If you look at the amendments outstanding, still to be debated, I think is not so long ago there was 108. I think it's down to about 60 now. But certainly the tenancy reform aspects really need to be scrutinised further and agreed on by Parliament before becoming law.
Okay. Question from Rod. I have not been able to find out how the matter of student lets is to be dealt with under the new legislation. Can you advise?
Okay, it's not clear. It's not clear. There is certainly government is being lobbied to try and get private student accommodation sat within the same framework as the purpose-built student accommodation. So that gives them some flexibility and scope around occupations and tenancies. We will have to wait and see whether they're successful in lobbying government to make those changes. And that's really why I think this is very difficult and highlights one of the aspects. This is a real concern in the county with student accommodation. And I think really that until clarity is made on this point, until we can come to you, through the responsible landlord scheme, through our newsletters and updates, when we have the information, we will certainly circulate it to all our members. But there are well, I think there's changes across the whole private rent sector. That the idea of this bill is it will bring about substantial reform. So there will be changes, there will be implications. Government is at length to reassure landlords, and certainly through the National Residential Landlords Association and ALA, they are both supportive of this bill's proposals, and that should help inform and reflect on landlords.
Then Carly, there seems to be more emphasis on the landlords paying out to ensure maintenance, but the current housing benefit is so low this will push people out of the landlord market. Are Cornwall Council going to be reviewing the housing benefit allowances?
Okay, I don't believe we are. There are discretionary housing benefits, I would say, for some people in certain circumstances. So if you have a tenant who is struggling on housing benefit, they should contact the council to find out whether they're entitled to any discretionary element. I think really that I think there is some information around this that may be helpful to members, and I need to dig further into it myself, which is the impact assessment of the bill is published now. So if you do a search on Renters' Rights Bill and go onto the government website, you'll get taken through to the various documents that are available at the moment. So that's all the readings to date, all the amendments that have been tabled to date, and the outcome of those amendments. But there is also the impact statement. So that talks about which areas within the private rented sector will be impacted to what degree, and because landlords come in all different shapes and sizes, for want of a better word, for different, the landlords for different reasons, it will affect many in different ways. I think for myself, my experience of working in the private rented sector in the county is we've got a lot of small landlords, and it seems to be becoming more apparent that smaller landlords are likely to feel the impact of these bill provisions more so than large investment landlords or portfolio holder landlords who perhaps in some ways have more business investment considerations for the accommodation that they let.
Thank you. So a question from Daniel. Martin, is there a time frame on the next bill consultation?
No. We are Cornwall Council. We are in touch with government ministers, and they are updating us as things progress. But still seems to be quite a loose timetable at the moment. Usually with legislation like this comes through, you would have, once it becomes law, you'd have a statutory instrument which sets out the fine detail and the implementation dates. And it's at that point, I think, we will be in a much stronger position to inform landlords and have debates about overcoming any obstacles it presents to them, really.
Okay, another question from Mark. Any updates on court improvements? Under the new proposals of possession matters, will need a court order, but delays in court processes will lead to major delays. I dealt with 25 possession claims last year, only 6 in court, so another 19 go to court, major delays.
Yes, real concern, really real honest and genuine concern for many landlords around gaining possession of their property. I think the government says it will ensure smooth transition through the courts process, and its suggestion at the moment is much of it will be digitalized, so it will be online with consideration of documents. But I'm not aware of how far that has been progressed to date, and whether it will be indeed progressed to be in place when these provisions come into effect. But it is a genuine concern from being put to government that the court process will lead to unfair, undue delays for the landlords regaining possession of their property. So yes, still a lot of work to be done around the courts, I think, but streamlining the processes may go some way to reducing the delays for possession hearings.
Thanks, Martin. That's all the questions.
Okay. Well, I would like to thank everybody for coming again today. I hope that's been informative. I would encourage you, if you want to find out more, by all means, you can email me. I think Laura's put my email in the chat box. You can email me. I'm happy to talk about any concerns or issues you had. The main communication from our perspective will be through the Cornwall Responsible Landlord Scheme. I'll just reiterate again, you can join on the Cornwall Council website. It's free, and you'll receive newsletters, future webinars like this through the scheme, and also fact sheets around the legislation as its provisions start arriving and coming into place.
Thanks, Martin.
Okay, so I think we will close this event now. Again, I hope people have found it useful, and by all means get in touch.